As my colleague Dr. Rozell said, President Bush has definitely exercised, or has attempted to exercise, an expansive use of executive privilege. Pretty much it's been a flawed use, and more than likely than not, the examples or the cases he's used to expand executive privilege will have the opposite effect than what he intended, which is the expansion of presidential power. Now, there's various cases that we can go over to show the defined, or at least President Bush's definition of executive power, expand use of executive power, but I think three are telling. Not just with presidential power, but I think with interbranch relations with Congress. Now, the first is actually also his first claim of executive privilege, and this had to do with President Bush's EP claim on documents relating to a closed Department of Justice investigation into an FBI corruption scandal with the Boston mob. Now, the House Government Reform Committee sought these documents. You know, this is a corruption case on the FBI. This is a case that had been, by the way, closed for 20 years. So over 2 decades. The Bush administration said no to disclosure. They said, you're not getting these documents. Again, a case that had been closed for 20 years. Typically on executive privilege claims for ongoing criminal investigations, that's okay. It's an ongoing criminal investigation. This one was not. So what ended up happening, and I think was probably the best thing you can say about congressional Republicans during the early part of Bush administration, is that they coalesced together and countered executive power. So you had Republican members of Congress pushing against the Bush administration, or I should say pushing against President Bush's claim of executive privilege. They pushed against this claim, and they eventually, after seeking these documents, received some of the documents and claimed victory, and that's the only time that congressional Republicans pressed against any EP claims by the Bush administration. A brief example of a year later, when the administration was again claiming secrecy on a energy task force case, you had congressional Republicans who obviously were still in control of Congress from 2001, well, pretty much 2001 to 2006, that year where Jeffords switched parties. That case, Republicans didn't press for disclosure of issues for the Energy Task Force case. And this case went all the way up to the Supreme Court. And it's tragic in many ways, and the one I want to highlight here is this Energy Task Force case became a Supreme Court case where it gave the executive, I think, a tool, if you will, for future use of executive power and executive privilege. And again, this is an Energy Task Force case, Supreme Court case dealing with Cheney and the vice presidency. Now, the second example I want to give is an executive order. And Dr. Holt had spoke about executive orders and saying that, you know, most of them aren't going to be overturned, and I do agree with that. This is one I think that's high profile enough where it could be overturned. And why I say that is Bush's executive order had to deal with the Presidential Records Act of 1978. Now, the Presidential Records Act is by and large a housekeeping act that Congress passed in order for there to be a proper or timely disclosure of administrative documents after a certain number of years had passed. Well, President Reagan had signed into law executive order during his time in office, restricting somewhat the disclosure of information. However, President Bush, in his first year in office, he modified President Reagan's executive order, greatly expanding the power of current and former presidents to guard information. And what I mean by that? Well, first, the executive order allows for current presidents to place executive privilege claims on any former administration or previous administration's presidential documents, and do that so indefinitely. So a current president could, incoming President Obama or this administration could place executive privilege claims on Clinton, on the first Bush, on Reagan. The second component of this is that former presidents have executive power. Now, they have the ability to claim executive power. Again, let me say, former presidents have executive power. That's what they can do, is they can claim executive privilege on their own documents and do so indefinitely. Now, Congress really did not push back on this, and again, this is a time when congressional Republicans were in control of Congress. By and large, you had special interest groups that went to court to try to overturn this executive order. What happened was the court ruled in favor of these special interest groups on a small piece of the executive order, and that is that former presidents cannot indefinitely claim executive privilege on documents. They can still do it, but it's the measure of length there, which is it can't be indefinitely now. Now, my final case I want to go over really quick is one of the more current executive privilege claims, and that has to do with the U.S. attorney's firings within the Department of Justice. What had happened is during the second half of President Bush's administration, he sought to, at least the administration and Department of Justice and the White House counsel's office, sought to get rid of some of the quote-unquote underperforming U.S. attorneys, or at least that's what the claim was. Now, the Congress started investigating this after hearing newspaper reports saying that there was a partisanship in this and it was a political corruption issue. Some of these U.S. attorneys weren't doing what the politicians wanted them to be doing, prosecuting certain immigration cases, so on and so forth. Well, the Senate and House Judiciary Committees initiated an investigation. That investigation resulted in the request for documents and testimony by White House staff and Department of Justice individuals. The administration gave some documents, but they refused other documents, and they also refused to allow for the White House counsel, Harriet Miers, to testify, among others. Now, what happened here, and it's interesting, and I think it touches on a broader issue of executive power, which is this claim that the administration has made. And this is a brand new claim of executive power, which is absolute immunity. And what this means is they have President Bush's former staffers, current staffers, have absolute immunity from going before Congress and testifying. Traditionally what happens is former staffers, current and former staffers, what they do is when Congress requests them to appear for testimony, they go. And they say, I can't talk about this, and make an executive privilege claim on a question-by-question basis. Here, that's not the case. What happened was the Bush administration said no to even appearing. Currently, this is in the courts, in the D.C. Circuit Court. The district court held that there is no basis in law or history for an absolute immunity claim. But what Bush is trying to do, or the administration is trying to do, is expand presidential power in this case, and they're hoping to press it as far as they can go. And right now it's in the circuit court, and they're not going to hear this case until early January at the earliest. I'll end on this. I think the Bush administration's flawed reasoning with the U.S. Attorney's firings case with absolute immunity, I think it's an executive order, also a flawed use of presidential power, is largely going to recede into history, and I don't believe it's going to be a valid precedent for President Obama or future presidents to use. I will end by again saying that President Obama, if he's going to do anything to counter President Bush's actions, he will first take on the executive order, modify that, and then second is with the U.S. Attorney's case, he'll compromise with Congress in releasing documents and or at least telling former staffers that there's no absolute immunity that guards them from congressional testimony. Thank you.